So for everybody out there that's logging in, we got 275 people logged in. My name is Peter Hecht. I am one of the co-founders of Magna Legal Services. Magna Legal Services was founded back in 2007, so I've been around for 18 plus years. I built our court reporting division, and I am the head of sales and marketing. And my partners are Mark Calzaretta and John Ackerman and Bob Ackerman. And we're going to dedicate this, this CLE today to Bob Ackerman, because he's the man, the myth, and the legend. We've got some great people here for you to learn from today. We're going to be talking about prepping witnesses, witness prep. That's probably the gist of the CLE today. I really didn't read any of the paperwork because I'm just catching up here. But I would just think that I would be the worst witness ever. I don't think I would be very good. I think I would make Mark, who is our resident jury, witness prep expert at Magna Legal Services. I think you probably would earn your living, working with me. And I would want to make Mark work really hard. Mark Basurto from Magna, previously from Cogent Edge, who, everything is great about Mark, except the only thing that, that doesn't really resonate well with most people is Mark is a Jet fan. Yeah, I said it right here live. Mark is a Jet fan. So, but don't hold that against him when he's prepping the witnesses. He's not a loser like the Jets. He's a winner. He's a winner. And I'm a Jet fan too. And by the way, so is Bob Ackerman, Mark Calzaretta, and John Ackerman. All the founders at Magna are Jet fans. And then we've got Susan Metcalf. You're going to meet Susan today, and I want to say a couple things about Susan Metcalf. She's from the prestigious law firm Potomac Law, and she has participated. For those of you that don't know, Magna does a fundraiser every year, or we did one up until last year for 10 years in a row, for Children's Hospital of Philadelphia, and it was a competitive mock trial, and we called it Chopped for Chop. And the combination there is that if you ever watched the TV show Chop, it's a competitive, eating, chef show. And so we made it a competitive attorney show. And instead of cooking up a meal, Susan would have to cook up a case live, in front of a live audience. And we would do our best to try to throw her off her game. And, she would compete against 3 other attorneys. We did it for 10 years. Okay. Susan was a Chop for Chop champion 4 years in a row. So she's the only person that won 4 years in a row. Ted Scher won 3 years in a row. Jerry Hamilton won 2 years in a row. And Tara Edwards won 1 year in a row. So she is the champion of champions at Magna. And what does that mean? That means that she can handle any kind of witness. And we've thrown all kinds of crazy witnesses her way. And she, by the way, sees over hundreds of witnesses in her regular practice. And then we've got Scott Nunnery from MC Consultants. Big shout out to Dan Dukeman. Dan, I hope that you're on listening. We love MC Consultants. You guys got great experts. We love that you're going to be supporting the Battle of the Experts taking place on December 12th, 11th and 12th, I believe, in South Beach, Miami. So for anybody that hasn't registered for that, wow, you guys got 307 people. 307 people. All right, so before we pass the baton over to Ross Suter, the resident expert of all things litigation consulting at Magna. I mean, this guy was a practicing attorney, and we were lucky enough to get him to join the Magna team. And really, he works with all the salespeople and all the clients, and putting together really neat solutions for their cases. He's going to be moderating today's session. But before I pass the baton to him, I wanted to just say, if you hear anything that you like from Mark Basurto, and you don't know who your sales rep is at Magna, and this is before the CLE starts, so I'm just giving a quick little plug. Give your Magna reps, or give us a call at 866-624-6221. We'd love to help you, and we'd love to give you a free case consultation. So that's all the selling I'm going to do, Ross. Did I break any CLE rules?
I don't think so. You're always a tough act to follow, though. That's for sure.
Really?
Got to bring the energy.
How about we do this? Before we get into the CLE, I'm going to tell Phil, let's all make our best screenshot faces and get some screenshots so we can post something on LinkedIn. So hopefully, Phil, you're getting some good pictures of us. I want a flattering picture. Yes, this is me. You can get these for $9.99 at Magna Legal Services. Go to our website now for a limited time. They're available. You can have one on your desk, put it on your night table. Scott, I think you could probably use one. You could bring it to your house and prop it up at your kitchen table. Anyways, thank you all for volunteering, and have a great CLE.
All right. Thanks, Peter. Yeah. So it's interesting. I think we're going international. Looks like somebody might be logging in from Mexico. We got Key West. I mean, there's coming in from some exotic locations. So we gotta be really good to keep these people engaged because they got a lot of nice things that they could be doing. But anyway, hey, my name is Ross Suter. I am the Senior Vice President of Litigation Solutions here at Magna. Peter did a nicer intro than I ever do for myself. I usually say I'm a recovering attorney, but I have been practicing, or excuse me, I've been at Magna for about 17 years now. And the good news for you all here today is I hopefully won't be doing too much talking because I have such a great panel. We actually had a couple calls and a call yesterday, and we could probably go for 2 hours. Now, we're not going to do that to you. This is a 1 hour CLE, but it really is a fantastic topic. We have fantastic panelists that run the gamut. So with that being said, rather than me introduce them, I'm going to let each participant here, each panelist here introduce themselves. And I'll start with Susan, who's been a longtime friend of Peter and I's, as well as Magna. And, he took my thunder about introducing to her as the Chop for Chop champion. She has been really, really impressive in what she's done with that and other cases we've worked with her on. So with that, Susan, I'll turn it over to you.
Oh, sure, Russ. I'm just thrilled to be here, and I thank everybody and Peter for the great introduction. And I have to say, I've worked with Magna for, oh gosh, many, many years. I've been in practice for 25 years. I've probably worked with Magna that long. And just, an incredible group of people. And I'm so impressed getting to know Mark through this preparing for the CLE has been really enlightening. And we have a meeting of the minds on a lot of these things. So I'm looking forward to talking with you all. And I'm a bit of a unique to Magna, I think, and to, my practice is a little bit unique. I have done a lot of corporate type work, commercial business litigation, but I also do catastrophic injury cases, high dollar defense work, because I love to get into the courtroom. And a lot of the commercial cases, they settle because business people tend to be reasonable and they tend to want to mitigate their risk. And sometimes the people on one side or the other, usually the plaintiff's bar, may not be reasonable. And those cases will try. And that makes me happy to get in there. So I'm very grateful to Magna for giving me the opportunity to be here today and also to compete in those chop for chops. And I hope they bring them back soon.
Well, we're lucky to have you. I'll turn to your left, at least on my screen. I'm assuming everybody's, and I'll let Scott introduce himself as well.
Hi, my name's Scott Neri. I'm actually not an attorney. I'm an architect, and I'm actually on this panel, essentially kind of representing the idea or the approach of being an expert witness. I've been an expert witness, I don't know, 30 sometimes maybe. My background is I was 27 years in practice as an architect, designing all kinds of different projects. And I've been actually doing forensic architecture for about 13 years now. And I specialize in premises liability and construction defect matters. My background helps me out on that quite a bit. I find this really interesting and intriguing. I'm going to be kind of presenting again just thoughts about what I've been through and some anecdotals, kind of stories about I guess what I've been through and see what both Mark and Susan might have to offer about what I've been through and how I handle it versus maybe how I should have handled it.
All right. And of course, thank you, Scott. And of course, last but not least is Mark Basurdo. I've gotten to know Mark now over the last 2 years, and I've gotten to learn about the way that he and his team at Cogent Edge preps witnesses. And having now spent some time with him, I think I would have probably renamed this CLE into turning witnesses into advocates. I don't want to give away too much of the CLE at the beginning here, but I really do think they have a very novel approach. And with that, Mark, why don't you introduce yourself, please?
Sure. I'm Mark Befurto. I am the national managing director of jury consulting for Magna. I assumed this role in Magna about a year ago. Me and my group from Cogent Edge, we were part of an acquisition by Magna almost 2 years ago. And our group is a group of licensed attorneys who do exclusively witness preparation, preparing people for deposition and for trial. Although I'd say our primary focus historically has been about 75% deposition, 25% trial. And so looking forward to the opportunity to work with the panel. We got together yesterday and had a great little experience. We wanted to we wish we had done that live for today because it was a really good experience for all of us.
We just all got dressed a little nicer today.
Yes, we did.
We're going to bring the same info. So yeah, thank you, Mark. Couple things administratively before we jump into this. One, questions. There's a Q&A button down there. Feel free to put your questions in there, and I'll try and monitor that as best as possible. And we'll answer mostly, I hope, live, should we have time. But if we don't get to a question, please feel free to follow up with any of us afterwards. The other thing is there are going to be administratively some polling that goes on throughout the course of this. Some of it is we want to get engagement with you all. We want to find out your thoughts on various different issues. And the other part is we need to do it for CLE accreditation. So not telling you which one's which. So I just will please answer the polling questions when they arise. And with that being said, Phil, if you wouldn't mind pulling up that first polling question, we can start there and then we'll jump in. And you can see what it is. They're simple. There's no hard questions on this one. But which would you rather do? Take or defend a deposition? And unfortunately, we cannot vote. Mark and Scott.
I would like to vote on that one. I have a very definitive opinion.
Phil, if you can let us know when we have a pretty good number of respondents. Nope. There we go. Most people would like to take, about 2/3 almost.
Yep.
So I think that kind of fell in line with what we might have expected.
Yeah, that's definitely, I will say, if I were able to answer that question, I'd say hands down, I'd rather take a deposition any day of the week because I'm in control of it. You know, it's more work a lot of times because you really have to do your research. You have to run down every question. And then, you know, you got to pay attention. You got to circle back when they deviate and go down a different path. But defending gives me so much anxiety because I am not the one testifying. I know the facts. I know how it should come out, but I also know that people get really nervous and they say things they don't mean and they don't necessarily listen. They answer a different question. They go down a rabbit hole and I can't control that as I'm sitting in there in the moment. I used to, in a former life, I was a middle school English teacher and I had to direct the school play. And it's just like that. You get them ready. They know the script, they know the facts, and then you put them on stage and there's nothing you can do about it. It could be a disaster, it could be beautiful, but you can't control it.
I'm sure everybody on here has a story where they're like, why did you just say that? We talked about this. And, you know, it's depositions. And by the way, we're talking about testimony in general, but mostly for the deposition, right? Deposition, you get locked into your positions to a certain extent. Versus trial. So there'll be a little bit of talking about trial, but I think most of the time we're going to be talking about this from a deposition standpoint. But you know, we've all had that situation where somebody says something and now it's like, uh-oh, how do we handle this? So, you know, nobody's going to be perfect. Depositions are not a typical way we communicate. People generally want to predict where somebody's going and they want to answer the question. and then they might want to help the other person. And that's when you're probably kicking them under the table and saying, stop helping. We need to, just answer the questions as they're posed. But I really do. I think before we get too far into this, I really think it's important for Mark to give people an idea of how we're looking at depositions, maybe a little bit differently than the normal. And actually, I don't know, before we do that, maybe we should put that other poll up with those 3 questions. And then Mark, once we get those answers, okay, we'll have to do them 2, 3, and 4. I thought we could do them all at once. Sorry about that. So we'll leave them up for just a short period of time, just not to belabor the points. So if you could answer as quickly as possible, that'd be helpful, because we do have a lot of content. I mean, honestly, we spoke for way over an hour yesterday about this for a 30-minute conversation.
And, I'll chime in. We came up with these questions yesterday because, there's a lot of conventional wisdom. And our aim today is to maybe challenge some of that conventional wisdom and talk about some methods that I've used myself, that I have learned that Mark uses regularly. And so it'll be interesting to see how people respond to these. I'm looking at
about 70% now. Say as little as possible. Phil, if you could just keep pulling up the question 3 and 4, please.
That is something, right? We've the conventional wisdom is, leave everything open. Don't answer anything that you're, just yes or no. Don't elaborate, because that leaves us open at trial, right? If the opposition never gets to a question or a certain fact, and your witness doesn't have to answer it, you're free at trial to, there's no potential for impeachment, and that gives us more freedom. And that's, I think, the thinking behind that. And we're going to talk more about that. I know Mark's going to weigh in on that.
Yeah, for sure. So both, okay, both 50%, lawyer 20, witness 31. Then the last one, please, Phil. Yeah, and I mean, I think we've talked a little bit about this, and it's just really interesting because I practiced eons ago, and if the only words that the witness ever said throughout the course of a deposition was yes, no, I don't recall, like that was a great defense. That was the best deposition ever, and that's not necessarily the case. And I think one of the things that I came away from after working with Mark a little bit over this years is think about how many cases go to trial and where is the battleground these days. It's in the discovery, it's in the depositions and all of that. So, the less a witness says during a deposition you're pending, the better. 76% of people agree with that. And I think all of that is in line with the way most people have been taught to handle depositions. And I think we're saying, okay, hold on. Witnesses aren't just there to be there, right? They're there to be advocates. And I don't want to step on Mark's toes. Mark is going to do a much better job of explaining, how we look at this than I could. So, Mark, take it away.
Bar is high, set high. So a little bit about where I'm coming from as I talk through a lot of this stuff. The way I look at this is that, doing a thorough and proper preparation of a witness, and particularly who I'm talking about is your client, like a party to the case, whether that's an individual or an employee speaking on behalf of the company. Preparing them for the deposition is probably the most important task you will undertake in the entire litigation short of trial. Why? Well, the one event that is most likely to impact settlement, the most likely to impact a verdict down the road, the only time that the opposing attorney and the opposing party can really evaluate your client is going to be in that deposition. And with more and more of them being videotaped, what the result is of a bad videotape deposition, which is that they're going to try to play some of those sound bites in court in front of the jury. And what do I want to accomplish with a witness? Well, what I want when I have a witness that I'm preparing, particularly, again, one who is a client who may be a party to the case, is to present a witness who is likable, And what I mean by likable, I don't mean that you go out and grab a beer with this person. It means that they're somebody who displays themselves as being competent at their job, that they are confident in what they do and what they did in the case, that they are able to demonstrate that they are caring, thoughtful, compassionate people, and that they maintain their credibility throughout their testimony. The problem is we set them up for failure in the way that we often instruct them without giving them context. Because what do? We often tell them, well, just give short answers. That yes, no, I don't remember, I don't recall are the best answers you can give. Don't elaborate. Just answer the question in front of you. Save your best answers for trial. You can't win at deposition. You can only lose it. And the one thing that happens, and I can tell by some of the results of the polling questions that we got about instructing people to keep their answers short and saying less is more, is that this instills fear inside of your clients and witnesses. So that when you need them to perform, when you need them to stay in control of the answers and not let the lawyer on the other side take control, they won't do it. They will default out of fear into giving bad answers, when typically it's your client. It's these people whose conduct is at issue, who are the experts in the room, not only on the subject matter, but about what happened. And so we want to actually empower those people to be their own best advocates for yourself and for the company when that's at issue. What does that mean? When you've got someone who needs to establish that they met the standard of care, when you have somebody who needs to testify in a way where you need to get expert support based on their testimony, you're going to need them to advocate. You're going to need them to talk about what they did and why they did it in order to get that message across, to demonstrate those 4 C's of likability that I was talking about before. The problem is twofold. One, not only do we instill fear inside the witness by giving them these instructions that are intended to limit them, but they also come to the table with a lot of different emotional baggage and anxiety, either about testifying or about their involvement in the case. And the approach we take is one where we have got to resolve the anxiety and emotional components, those factors that are influencing how they're going to testify, before we can really teach them the main points in the case or how to use certain tools to become advocates for themselves. If you explore just a little bit, you will find that many people, particularly your clients, your people representing the company, have either a fear or anger about being involved in the case or having to give a deposition, about being sued. They have a fear of confrontation, right? Having to deal with that confrontational aspect of cross-examination during their deposition. They might feel guilty or responsibility for the actions that took place. They might feel ashamed that they're involved. They might have a certain level of arrogance or insecurity. They might be, as many people are, I'm sure, in this webinar, they may have a little bit of perfectionism inside them, which may lead to them second-guessing themselves during their testimony and be susceptible to sort of those influential, suggestive questions that opposing lawyers love to ask. And if you don't resolve those things first, you're never going to get a witness who's going to be able to testify effectively. So how do you figure all this out? Well, I start with the premise that, look, I can't just lecture the person. We're going to teach, and this is something I would encourage all of you to do with your witnesses moving forward, is to start going back to law school and the Socratic Method that we were victims of during that first year contracts class. Why? Because if you teach with questions, you can accomplish really 3 things. 1, you get the witness to own everything that happens in the room. they will take ownership of the process because the conclusions that you come to will be theirs, not what you necessarily tell them. 2, you're going to really know whether this person's absorbing what you're telling them. I'm sure you've all had the experience of a witness who's walked in and testified, and you say to yourself, I told them not to say this. I told them not to do that. I thought we had this discussion before. And they're saying things to you that seem like they didn't listen to you. They probably didn't. They probably tuned you out. And when you lecture and continuously lecture, you'll never know what that person is absorbing. Finally, another advantage to asking questions is that you will be able to see from the very beginning of your prep session what the baseline is for your witness and what might be driving them in that moment. So does your witness know how to answer directly? Do they go off on tangents? Do they tend to ramble on and on and on so that they've forgotten the original question? Do they know how to give a direct answer to a question, or do they come across as evasive? As you give them more challenging questions, you may see that the witness becomes more and more evasive because they're afraid if they give a direct answer, they're going to get cut off and not get an opportunity to explain. And so using questions from the very beginning can be a very powerful tool to get your witness to open up and to expose some of their shortcomings that will prevent them from being good testifiers at deposition or at trial. So I want to get them from the very beginning to focus on listening to the question and to discipline them when they don't respond appropriately, that they need to listen carefully. And that might be with an instruction, or a question back at them. Well, what was my question? Can you repeat back the question I just gave? Well, why did you miss that word? Or why can't you repeat back the question? So that you start getting them into discipline to listening carefully. Once you're able to do that and go through some of these emotional issues and get them to understand what it is that's impeding them, you can turn around and empower them. You can give them confidence that they can be in control, that they can control their answer, they can control the words in the answer, they can control the pace of the deposition, right? How quickly do they have to answer? They can take all the time that they want to answer. They need to understand they're not playing a game of Jeopardy, that they can actually take their time, and that will not only help them get the answer right, but it'll help show that they are thoughtful, deliberate, intentional people. When they get a question, and lawyers do this all the time, right? It's why people hate us. We create a narrative inside the question. And that's where I operate from, that the lawyer on the other side, their objective, if they're doing a good job, is to create a narrative, and they want to get your client to adopt it. And they do it with their questions. And I am 100% certain you cannot get your message out without speaking a little bit more than yes or no. To get your narrative out, to defeat the other opposing lawyer's narrative, you gotta empower your people to speak and do a little bit of advocating for themselves within reason and control. So what does that mean? What do we want to teach them? We want to teach them to be direct. And that directness is not just yes and no. It includes other things like it depends, not necessarily. Sometimes it means saying, I can't answer that question because I don't have personal knowledge of it. I wasn't present. Or, you get a question, for example, Scott gets a question as an expert that's outside the scope of his expertise. He should say so. I can't speak to that. That's outside the scope of my expertise. But it's being direct and then teaching people how to give a short, efficient pivot that allows them to take control of the narrative. And you can teach them with a really simple question on a benign question. I asked Ross the question yesterday. I asked Ross, can we agree? And it might be the first question out of the gate, who you work for. I say, Ross, you work for Magna, correct?
Correct. Yes.
And so that one word answer, it's a great answer, right? It's direct, it's truthful. But right now, who's controlling the narrative? It's me with my question and the witness giving the one word answer. To get Ross to start advocating for himself, all he needs to do is add a little bit of something. Yes, and I've worked for Magna for 10 years. Something to that effect. You can teach that to anybody. You can teach it to your doctors, right? If you represent a doctor. Yes, instead of saying, yes, I'm a doctor, yes, I'm a board certified cardiologist. Or yes, I've been practicing family medicine in this community for 25 years, right? I work for Walmart. Do you work for Walmart? Yes. And I've worked at Walmart as an asset protection manager for 20 plus years. It's just making that little extra point to teach people how to take control of the narrative. Even on when you get to more general attacking questions, we know lawyers love to ask these broad general questions. You want to teach them that they can take control. For example, lawyer might ask in a case where a patient has had a brain bleed and the doctor's being sued, the ER doctor's being sued for not, ordering a CT scan of the head. Lawyer might ask a very general question that's really problematic. For example, isn't it true that a CT scan of the head is used in emergencies to rapidly diagnose life-threatening conditions like a brain bleed? The answer to that question is likely yes. But when that doctor didn't order a CT, he better say why. Why would you leave that on the table? And so what I would teach the witness to do is to say something like yes, or it depends, and say, but in this case, it wasn't reasonable to order a CT because the patient's headache resolved with Tylenol, the patient didn't vomit, complain of any vision loss, or and didn't have any neurological deficits, right? We want to teach them to be advocates. And what that means is we want to psychologically empower them to be in control by breaking down barriers that might prevent them from being confident advocates for themselves, teaching them the right tools and the limitations of how to be direct and make a point, and then to articulate the narrative that you want them to get across in the case. And that is really, in my view, the objective and the way to really prepare a witness to testify. Now, I know Scott has experience testifying. Susan has seen this happen, millions of times. And I kind of want to get their involvement a little bit to explain what their experiences have been like and whether any of this resonates with them.
Mark, I would love to jump in here because I want to come back to something that you talked about, the anxiety that witnesses feel. And I think yesterday you described what you do as a little bit of therapy, and it's like psychotherapy. And it is. You reminded me of a situation, and there's a wonderful question in the chat from Walter. I'm going to scroll back up, and he said, how many attorneys have been instructed to tell a witness this? You've just taken an oath to tell the truth. Do you understand that if you testify differently at trial than you do today, you could be subjected to perjury? That is a recipe for making your witness choke. I mean, you have just upped the anxiety level tenfold. I was in a prep session once where we had some other lawyers come in to help, and one of them told the witness, and she was so sweet. She had that anxiety Mark mentioned about, I feel bad that I got the company in trouble. I feel responsible for this. I feel shame. I feel anxiety. Am I going to be fired? And this guy said, oh, if you say that, we're going to shoot you. And the next day he was off the case. That witness called me and she said, oh my gosh, Susan, that was just, I don't know what to do with that. And I said, you leave it to me. But that is you have to put yourself in that witness's position and you have to understand what are they feeling. I had if I can tell another quick anecdote, I had a case where the opposition was gunning for the CEO, a very large, huge company. And they were trying to harass. They wanted to get his deposition. They were trying to show that he was involved somehow. I was prepping a middle manager. And I said, I think they're going to probably ask you what you think of the CEO. Do you have an opinion about this guy? And he looked miserable. And I said, look, safe space. You tell me what you honestly think. And he said, I think he's a bleepity bleep. I said, and I didn't say, oh my God, don't say that. I said, okay, let's explore that. What do you mean? What makes him seem that way? He said, well, he's really demanding. I said, so he has high standards. He said, yeah, that's true. He said, well, he can just be very blunt. I said, so he's frank. He's candid. Would you agree with that? And we explored ways that this guy, people want to tell the truth, and we need them to tell the truth. It is our ethical obligation to encourage them to make sure that they tell the truth. But there's a way of putting things. And by the time we were finished, this guy was so relieved and relaxed because he now had a way to tell the truth without saying it in a way that was going to get him fired when the CEO reads that deposition.
Yeah, we sometimes get caught up in our own bubbles, right? And there's our truth, the other side's truth, and then ultimately the trier of facts truth. But Scott has a different perspective, right? He's the witness. And I know we talked a little bit about your personal experiences and how that prep can really either positively or negatively impact your performance. If you wouldn't mind sharing.
Sure. And Mark and Susan both really touched on this kind of thing. But I know when I first started out in my first couple of depositions, you get prepped for making sure that you remember what your opinions are and what the basis of your opinions are. And you kind of lose sight of really what happens in the deposition, what's okay to do, what's okay to say. Things as simple as taking that pause after the question is asked, not only to take a breath and think about what you're going to say so you don't trip yourself up, but also to give, of course, your attorney the chance to object or state whatever they need to. But little things like even being able to ask the court reporter to repeat a question back. They're not off limits to be able to do that. It's okay to ask that question. And I think those basics of really how the deposition goes. I know at the beginning of the deposition, attorneys will talk about the rules of the road and things like that, but they don't cover everything. And plus at that point, a witness is probably madly thinking, okay, am I going to say the right thing? And maybe not picking up all of that. So it's always good to kind of, I think, go over the rules of the road before getting in the room with a witness. And I know there were other things that were talked about too, about as far as the runaway, I guess I kind of think of it as being, the simple answers of yes, no. You get directed to give yes, no answers. And the problem with that as a witness, and I did have this happen to me where, they were throwing softballs at me, and it was yeah, yes, of course, yes, and that type thing. Next thing I realize is that the deposing attorney was testifying for me. It was like a runaway train, and I was, trying to stop and say, now wait a minute, how can I do this? And I got behind, and so I was behind and trying to catch up that whole deposition. I think it could have gone a lot better for me, but I learned from that not to simply go with the yes no questions. There are reasons for that, and of course, even with the yes no, like what Mark was saying, you put a qualifier in that instead of saying yes, I am an architect or something, then you go ahead and say yes, and my background is, etc. I think that also gives you as a witness, or gives the witness the confidence. It helps them kind of build up this comfort and this confidence of yes, I belong here and I'm okay being here to be able to testify. And I think any of those little things that you can convey to the opponent beforehand, so that they get comfortable walking into that room. Even discussions about what about the other attorney, the deposing attorney. I've told the story about one time where I was just really focused on the facts and I was ready to go in, and it was right before I walked in the door, my client says something, oh, this attorney's a tiger, and this attorney shredded all these other people and stuff. And of course I went in there kind of wide-eyed, thinking, okay, and of course, then my whole thinking as this attorney was asking me questions was, where is that attorney going to try to take my legs out, And so I was probably overthinking my answers and all kinds of things like that I don't think were really necessary in that situation, and I think could have been avoided. But really, it comes down to making sure that the experts not only versed in what their opinions are and what their bases are, so things speak of those things, but also just ensuring that they're going to be comfortable in that environment.
And Scott, that's an interesting point, because Walter followed up and clarified that he will have to tell his witnesses. He tries to let them know that they may get asked that question at depo, right? Like the opposition sets you up and tries to scare you and say, if you say something different at trial, you're going to be subjected to perjury. So he's got a really great point that you want to prepare people that they might ask that. But then I would ask Mark, how do you tread that line between scaring someone like Scott into thinking that there's going to be a tiger on the other side and still preparing them for the tough questions?
It's a great question. I think it starts with preparing them with practice, like practicing those questions live during the prep session, and trying to get them to understand why the lawyer on the other side is doing those things. Like getting them to understand, well, when the lawyer, asks you the same question over and over and over again, why are they doing that? And get the witness to think about it. Because if the witness can come up with the answer themselves as to what's going on, the fear level, I think, drops tremendously. Because then they realize that they understand it and get it, what the process is, what the game is. And so it's the questions like that. It's the, well, you didn't answer my question. Can you just answer my question? We're going to be here all day if you don't answer my question. In fact, you know what? I may call the judge and get the judge on the phone so you start answering my questions. Practicing those things live during the prep session is, I think, it's invaluable to get the witness to understand that the lawyer is playing a game of intimidation, because they're likely doing a good job, right? When they're doing a good job, that's when the lawyer on the other side might ratchet things up a little bit. And those preliminary questions get said at the beginning, those preliminary instructions, I try to teach them, look, there are no set rules that you need to follow other than to be direct and tell the truth. That's it. And everything else that the lawyer tries to tell you to do is just an intimidation tactic to get you off your game. And as long as you see it and feel it and recognize it, you can handle it.
And so, depositions have definitely evolved over time in the way they're handled and the questions that we get. I think one of the big thing people really struggle with is, how do you address those unfair questions? Or what may feel like an unfair question, or a leading question, or a hypothetical that has nothing to do with the case. How do you instruct, or how do you handle a witness and have them do that? Or Scott, from your perspective?
Yeah, I with my background with premises liability, it seems like I get a lot of hypotheticals thrown at me in deposition. And right off the bat, the problem with hypotheticals in any situation is that maybe the attorney has a particular idea in mind of why he's asking or proposing or stating the hypothetical. But the truth is, you think about it, hypotheticals can have so many other factors and so many other reasons for things happening that you can't answer a question like that. And so I always have to resist on those hypotheticals. And, I know there's been discussion then about between attorneys, that hypothetical, you can't be, and you should be, and you shouldn't be doing hypotheticals and that type thing. But from my perspective, I will just flat out say, I can't answer a question like that, because you've got something in your mind about what's behind this hypothetical that is possibly totally different than what I've got in mind. And, for me to you start filling in what the deposing attorney is asking and you make assumptions and things like that, you get yourself into trouble. And so I think it's really important for a witness to know that, first of all, you don't help ask the question if the attorney is not doing a good job of asking a question, but also, things like that, throwing out a hypothetical that could go 1,000 different ways. You don't want to either make an assumption about where that's coming from and answer incorrectly. That could be maybe skewed a little bit to show a different perspective on it than what you had intended with your answer, but also to just realize that no hypothetical is black and white, and it's full of pitfalls and openings and voids and such that you resist to fill in, and you resist to answer as yes or no.
I know Ross has more ground he wants to cover, but I have a quick question for Mark about your practice. Do you ever videotape the witnesses in practice and show them themselves on camera and see what they look like? Have you ever done that? Is that something you should avoid or consider?
We don't do that often in our sessions. Most of the time I want them really focusing on what the verbal answer and response is. If we get somebody who has some issue with some sort of nervous tic, or they really don't present well on video, then we will do that and incorporate that as part of the prep on the second day. We usually break things down into 2 days. And on that second day, if we notice on the first day that there's a problem, but the underlying first day of the session, because there's so much of that therapy going on during the first day, we don't want to intimidate the witness by telling them this is all being recorded.
Right.
So, but day 2, if we're going to practice and there's some issue that people are concerned about in terms of how they're going to appear, then we would do that.
I've only ever done it when a witness has asked for it. Sometimes witnesses will say, I'd really like to see how I'm come across, but yeah, I'm interested.
Kind of equally, or tagging onto that, Mark, I'll throw it to you one more. Virtual. So many depositions are virtual these days. What's your thoughts on that, either as a prep or as a witness at a deposition, being virtual versus being in person?
Yeah, I think, when it's virtual, there are a couple of more things just to be mindful of in terms of controlling that environment for the witness. If somebody, for example, is presenting a document over Zoom, you can't see the whole thing. And the first thing I would ask for, as a witness, I tell the witness, you need to ask to see the whole document. Make sure that they're representing to you what is the whole document. And if you've got a paper copy in front of you, rely on that rather than the one that's being presented to you virtually. I would have people say, I can't answer your question unless I'm given an opportunity to read the entirety of the thing that's in your hands that you're using, because it shouldn't be a game of, hide and seek, where somebody's using something against them and they don't have an opportunity to see it. That's probably the biggest thing that we work on virtually, is making sure the witness understands the level of control that they can have over that part of the process.
And I want to turn to a couple things, because we do have a couple questions that I want to answer before we turn back to kind of our discussion. But I do like your comment here, Mark. I know there was a question that was posed to us. I don't think the answer went out to everyone, just because of the way our settings are. But really, the question had to do with offering the opinion that you need to be able to stand behind at trial. And I like what you said here, which was, basically with every witness, expert or lay, it's not a memory test. So it's an open book test, so they can refer to whatever documents that they need to, and then be able to take control of the demo. I think a lot of it is taking control. I think that probably is an underlining theme to what we want to talk about with regards to that. But I think one point that ties nicely into some of the things we're talking about here. It's a question here, and I'm going to get to the one before, but I'll take the second question here first. how do you balance empowering your witness to speak their truth, but making sure that they don't volunteer too much information that could ultimately cause problems?
It's a great question. So part of the prep session, includes covering with with the lawyer, right? With the lawyer representing the client, what are the critical issues in the case? And we make the witness work on helping frame those, because I want the witness to understand from the get-go what are the main things that you're going to be attacked on, and then have a plan for how you're going to deal with those. What are the messages we absolutely need to get across without fail during the deposition? And if the questions fall within those critical issues, that's where you get to pivot and explain. And so what I tell the witness, look, or what we teach them is, when you get a question, you need to be processing in your head. Is the answer I'm about to give going to be helpful to my defense in this case or not? If it is, expand. If it's not, you don't. For example, when they start going through, your legal history, how many times you've been sued as a defendant, that's not a place to expand and volunteer information, with one exception, right? If you say, well, how many times have you been sued? And you say, I've been sued 3 times, but all 3 of them got dismissed, that's positive for you. So get it out there and say it, right? If it's something negative, and something that, is outside what really the issues are in the case, then you keep the answer short and sweet. But the witness needs practice at that. Like, you can't just give them that context without context. You got to make practice, so that they can get that. They're like Goldilocks. They got to test the different bowls of porridge to find out which one is the right temperature for them and for their attorney. And, you work together to find that bowl of porridge that's just the right temperature.
And it's interesting. I have always taken the approach that even with my fact witnesses, now, if someone like Scott, he knows the case, right? He's an expert and he knows what the claims are and what the defenses are. But fact witnesses that you work with don't always know that, right? And so I find that it's often very helpful to give them an understanding of what the case is and the claims and the defenses. And then you have your themes like you're talking about, Mark. If they understand the case, then they get where the goal is, right? And they're not going to fall into the traps that the other side lays for them as easily. And I think and I've learned a lot in those prep sessions about my own case, right? I had a trademark infringement case where the marketing person who came up with the logo, I said, tell me why you picked this, right? And then I told her what what the elements were to make it original and unique. And she came up with way more than I ever would have thought of. And it was just a very collaborative part. I like to be partners with my witnesses, even fact witnesses. Is that something that you bring, or are there certain fact witnesses that you sort of want to silo and not sort of give them the big picture? How do you approach that?
I'm going to give one of my classic direct answers. It's going to be, it depends, right? And it's really situational. But I would say, and I think, Scott, you might be able to relate to this, doing a lot of like premises liability work. There are some common themes that we do want all fact witnesses to know and be aware of. In these sort of premises liability, like negligent security cases, you want them to know the theme that, hey, as a company, we can't prevent all crime on our property. You can't stop things like random acts of violence and things like that. Those are home base, like common themes that every one of your witnesses should at least appreciate, if not be able to say, right? So that they don't get themselves in trouble on those kind of leading questions where the lawyer is guiding them down the safety path or some other path that could really, really damage the case inadvertently.
We have a great question in the chat, Ross. Do you like that? And
yeah, I'm going to get that. But I think that this is something we touched on yesterday, kind of the standards and who sets the standards, and whether it's absolute safety or what, they're never going to be instructed in that. It's more about the reasonableness. I think, Mark, it was tied on to something I also wanted to ask you, because it touched upon things that were said about, facts versus advocacy and your role as an expert in the case.
Well, I'll speak up to that. From a witness standpoint, expert witness, we do really have to. We're being asked by our client to help them understand the nuances of the matter and what the claims are and how real and how accurate some of the claims are and allegations are. And for that, the idea is we do our work to try to come up with that information and supply it to them and show them and tell them and all those kinds of things. But at the same time, as an expert witness, we're not advocating. We don't want to be advocating. Because we have to recognize certainly that there's no perfect black and white, one side or the other. There's always going to be other issues, on the other side, that you have to consider, and that you really need to be open and honest about as well, and you have to address them, and make sure that your client's aware of those things in case they aren't aware, and it's really up to you to provide that the big picture, the level and equal, non-biased as much as you can. Given the bad news, sometimes I've given a lot more bad news than I have good news, and that's the fact, because that's the reality of not being biased and not being an advocate. And certainly I've been asked that in deposition, are you an advocate, that type thing, and so I've had to go ahead and fight that out, because certainly it comes across that way, because I'm answering questions and for defense or plaintiff, whatever it may be, in that regard. But the fact is, I will always work and try to be unbiased, and you've got to think about that when you're in the deposition, that you're not just sailing down that other avenue and totally forgetting really that you should be down the middle lane.
Yeah. And I do think thank you. Thanks, Scott. I do think this is a great question too, Susan, about, and then I'll throw it out to you and Mark here. From Mark, this is the question. Leading questions call for yes or no answers, followed by a witness saying yes and adding more, confronted with an interrogating attorney stating, my question is it just calls for yes or no. This goes on and on. Is the panel good with this course of the deposition? And what about the effect of a client or the witness being chided over and over again? Just answer my question.
And I put in a written response. I don't know if people can see it. I literally just clicked on the response. But what I would say on that is, first of all, you want to teach the witness that that's coming, right? And I would ask them, so when the lawyer does that and is insisting you just answer with a yes or a no, what does that tell you about the quality of the answer that you just gave? And they'll say, well, it must have been a good one because the lawyer didn't like it. Exactly. So don't stop. Why would you stop what you're doing? And so we have taught people, when they keep getting pressed like that, and it's been done, I think, very effectively. We've gotten a lot of positive feedback from people, from the lawyers we work with about this. When their witness chimes in and says, look, I took an oath to tell the whole truth, and that's all I'm doing is making sure I tell the whole truth. And that's oftentimes shut people up on the other side, or at least, gotten them even more frustrated. So now the lawyer's responding out of anger, right? They're losing their cool. They've lost control, but our witness has stayed in control.
Yeah. I'd love to follow up on this other question from Rosemarie, and maybe Scott can speak to this, about how do you counsel clients to answer reptile questions? And, Scott, do you get the questions like that? Well, doesn't the landowner have a duty to make it safe? Doesn't it, would you want your child to be walking in this area? Do you get questions like that?
Yeah, that's actually a really good question, Susan. In premise liability, you actually get that question most often is, well, don't you think that the management company, the property owner, had the responsibility to make their property safe? And of course, what does that really mean? And, you're thinking in terms of perfection. Like Mark said earlier, it's impossible to make every little thing safe because of the fact that people just for the sake of walking, like trip and falls and slip and falls. And, people have different walks and different gaits and have different abilities to move. And, one person's trip and fall could be another person's, doesn't affect me at all. Things as simple as like in a retirement home, having shag carpet that's so thick that the residents are tripping because their feet drag isn't a problem for, if it's in a daycare where you got little kids running around, and if they fall down, that you want something soft and that type of thing. So it's all, it's all within context. And the thing about it is, should it be safe? It's like, well, what is the definition of safe? Please narrow that down, is where I usually go with that.
Mark, do you want to weigh in on that?
And I would add,
Yeah.
sorry, go ahead.
No, I've been in that uncomfortable position where the lawyer asked a question that's completely unfair. And, wouldn't you feel safer as a security guard if you were allowed to carry a weapon? Like, and it's
Big question.
It's really hard to say. You can't say you can't answer that, right? So how do you prepare your witnesses for that?
So on the safety reptile questions, I always have to include, you're the lawyer representing the client and how we're going to answer this question. I operate from the assumption I'm not always concerned about which direct answer gets picked to start it. They got to answer directly to avoid coming across as evasive. But to me, it's, well, what does the whole answer look like? And I want to make sure that whoever the witness is, that they are comfortable with both the direct answer and the explanation. Because if they can't deliver it confidently, it's not going to land well. It's just going to be terrible. So I think there are some safety questions you could get asked, these general safety questions, where whether you lead with a yes or a no or an it depends or a not necessarily doesn't matter as much as what follows. And what I try to teach is, okay, if you hear the word safe or safety, somewhere in your pivot or answer needs to be the word reasonable. So even if you embrace that your job is to keep the property safe, yes, but we do as reasonable to keep, our patrons, our customers safe, because we can't prevent all, criminal activity, whatever it is, or we can't guarantee that people will be 100% safe all the time, right? Or, it might be, well, no, my job, if you give that to a doctor, no, my job is to take care of the patient, and medicine is full of risk. I got to decide what's reasonable, right, for the patient, knowing that there's risk. It's an effort to make sure that the lawyer who's asking the questions doesn't get the chance to establish that the standard of care is to do what is safe. As long as there's some more pushback to that incorporates what the real standard is, I'm going to be okay with however they answer it. There's got to be flexibility, I feel like, because some witnesses, they're uncomfortable rejecting the safety question. Like, they just won't do it. And if you push them to do it, if they forced to deliver the message the way you try to tell them, they're going to come across terrible because they're not going to be confident in it. So I want to try to find a way to make that witness be direct, but give an explanation where they're going to be comfortable, if that makes sense. And these questions, I saw somebody chime in about the speculation. You're right. That's where we teach people, you want to teach people to drive your pivot, if you're going to give one, to the facts of the case, right? You want to empower them when on a critical issue to go right to the heart of the case. Don't give an example that doesn't apply to the case. Use the case to help you. And there are going to be circumstances where that happens. And if the witness is properly trained on the issues and how to deal with the reptile, they can easily get there.
I told you time would fly.
Yeah.
So final polling questions up, but I do want to make sure that nobody has any other questions. It is great advice on how to answer the reptile question. If not, I do want to thank Mark and Scott and Susan for participating. I think it was great. I like I said, I think we could do this for another hour, maybe next month. But Anyway, if anybody does have any questions, please feel free to reach out to us. If you want a great expert, reach out to MC Consulting. If you want a great attorney, reach out to Susan at Potomac Law. But with that being said, if anybody wants to jump off, I get it. If you have any other questions, feel free. But thank you everyone for participating.
And the comments in the chat are great. And thank you for all your participation and questions. Really terrific.
And I apologize to anybody's question that we might not have gotten to. It's just there was so many of them, and it's great to see the engagement.
Ross, it sounds like we need another session sometime. I think there's more we could follow up on and get into. And I really thank you for putting this together.
Part due.
Yeah, thank you. Thanks, everybody.
Thank you.
Thanks, everyone. Appreciate it.
See you next time.
Thank you. I'm just watching all the stuff come through.
Well, I don't know if William's thought it, but how do you address the question about how long did you meet with your attorney in preparation for this deposition?
Oh, that's a good question.
Great question. I think that, every state I've been able to work in, there seem to be different parameters on what the lawyer can do in terms of objecting to that question. I know in a lot of places they'd shut that down, not let them answer the question. And I don't know how many judges would force an answer to that question if you instruct them not to answer it. But I don't think there's any fear. That's not a question ultimately that I think ends up in a courtroom, right? It's just designed to intimidate the witness, right? Making them feel like, oh my gosh, I spent so much time preparing. So what, right? They spent 10, 12 hours preparing. And, why did you need that much time?
Yeah. All those uncomfortable. And I'll tell you also, it's really important to know the law in your jurisdiction.
Yeah.
Another question that we always get that's very uncomfortable in Pennsylvania, I'm admitted in PA, New York, and New Jersey, but I practice all over the country. In Pennsylvania, you are permitted to ask a witness, what documents did you review? And that those are the documents the lawyer showed you, right? I have always thought that delves into the work product protection because that reflects what I think is important about the case. But in Pennsylvania, they have to answer. In Florida, they don't. I had a case recently in Florida. I looked it up because I expected that to happen. And that's protected. But these questions are always very uncomfortable. And it makes the lawyers uncomfortable as well as the witnesses.
Yeah. And I try when we're preparing, regardless of the state. Again, all of this is subject to what, I get with the individual defense lawyers we work with in different states. But we try to limit that. What did you do to prepare for your deposition? I met with my lawyers and I reviewed certain documents, right? I'm trying to make sure that they don't go and do their own independent research on things and stuff like that. Try to keep them from that. But sometimes sometimes we learn they looked at stuff they shouldn't have in anticipation of their preparation sessions. But we try to limit that and practice those questions during the prep.
And for those of you asking, those of you logged on, we have your attorney ID. We will take care of all the accrediting for filing of CLE credit. You will get it. You will hear from us. I'm not sure how quickly, but you will hear from us. Well, everyone, thanks again. Really appreciate your time. As always, you're excellent, Scott. Thank you so much. Hope you had fun.